So, hello everybody again. I'd so hoped that I was going to be joined today by my American colleague, who is a great expert in these kinds of situations, family drug courts, right across the board. But sadly, she is unable at the last minute to attend, so I'm afraid you've got to hear more of me. But I've got a picture of her coming up. There she is. This is Caroline Cooper, who sends both her warmest wishes and also her disappointment at actually not being able to come today, and particularly because she has the researcher practice perspective, which I think is pretty unusual. And she's a very forceful, powerful lady. Right, this is a rather large topic. I'm not quite sure why we're trying to do this, but I think where we wanted to start was saying something that I'd actually said earlier, that domestic abuse seems to be quite common in these cases where there's parental substance misuse. And there is an international consensus that that co-occurring problems are more damaging than single issues. So we don't really need to debate that. I've just given one example there. I wrote with a colleague who is a criminologist specialist an article looking at this sort of issues, just trying to survey the background landscape, and it's pretty powerful and incontrovertible. So I also, though, want to say very clearly, and it's really important, that it isn't inevitable and that the research is patchy and the interrelationships are very complex. Having said that, there's too much evidence about short and long-term harm and impacts on children across the piece. I listed them here: physical, mental health difficulties, emotional difficulties, problems in education and offending, and that some of these difficulties do persist into adult life. So we're talking about the risk of intergenerational harm and that they affect parenting. Having said that, I think that a really important point, and one that I think is very relevant not just for policy but very much for practice, is to look at the multiple entry points that there are into the family and criminal justice system. And you can see just how many there are. And I have to say, my daughter did this graphic for me. Whilst we're mentioning family members, Sophie did it for me, so I was very pleased about that, and she sent her greetings too. There are very good reasons why there is a reluctance from parents to say that domestic abuse might be part and parcel of the issues around substance misuse. Sometimes it's absolutely straightforward. Partners are silenced and threatened if they do say anything. So that's one real risk. And the other one, very potent, obviously, in the child protection field, is what is going to happen to my child if I say something? From the professional side, I think it's fair to say that these are difficult issues to raise, and you can see how many different agencies are potentially involved. And the question is, how much training do people get to go beyond the surface? So firstly, starting a bit with the legal framework, because this talk is more about the policy and the law. And the question is, how helpful is our framework? Now, that's a very big question, and it's quite a difficult one to answer. But in terms of the actual legislation, the Children Act 1989, which I think influenced Canadian legislation as well, does take children as the paramount consideration. And that is crucial, how the legislation actually starts. And here I've just listed briefly the key criteria which enable you have to consider within the court to consider removing the child or reuniting them. And the strength of the legislation is that it's very much based around child development. So significant harm, it's not categorical like it used to be, And the ill treatment and the definitions of impairment, etc., are very broad-ranging. But what is striking is that we get to the closest in the family law to talking about domestic abuse, with that last bullet point about witnessing ill treatment. And that's kind of code for domestic abuse. Perhaps it's not even code. It took much longer for the criminal law to come up to date. And it is regarded as landmark legislation to the extent that it's the first to go beyond talking about domestic violence, but to also talking about various categories like coercive control, emotional abuse. It's deliberately brought very broad. And equally, a very clear statement about the harm that comes to children and that they are victims in their own right. That's quite a powerful thing from the law. And that agencies need to work together. So it recognizes, in theory, the law underpins the idea of joining up the dots. The sentencing guidelines are interesting. They're not there in the States. We have them here. Whatever the issue, in all criminal cases, there's an obligation for the judge to consider what is going to be the outcome if, for example, a mother is sent to prison, or if a father is, and what will be the impact on the family. Doesn't mean they've got to do anything about it, depends on the kind of offence, but they do have to consider it, and that I consider helpful. Now, this is where, obviously, Caroline was going to speak, and these, I'll go through it fairly quickly. So, the context to developing these family courts came because of this legislation, which said that too many children were drifting in foster care, often with, most frequently, with parental substance misuse difficulties. So that was good, that they created that new opportunity. But at the same time, she is highly critical because they didn't even begin to think about co-occurring issues, and said that window of opportunity is 1 year only. And as you can see from the two following points, firstly, we all know that substance misuse, it's not just a question of a tap being switched on or off. It's a long process and does include, very frequently, relapses and a need for ongoing support. And I thought this was interesting. I didn't know it until she and I were preparing this together, that the American Association of Addiction Specialists reinforces that point about ongoing treatment and calls it a chronic condition. So I talked quite a lot before about problem-solving courts, and I think the only things that I really want to pick out from here is that they began in the States within the criminal sector, and there are differences also from the family courts in England, in that I was telling you how in England we don't have lawyers attending the therapeutic component. It's considered that that is not helpful to the parent to disclose and talk openly with the judge. And also there is a legal point about they might have to then use some of the things that are said in evidence. So, but in America, as I understand it from Caroline, that's not the case. Lawyers are there throughout. And they don't have multidisciplinary teams in the way that we do, which are permanent teams that within the local authorities where these courts exist, they tend to bring together different personnel depending on the case. So there's interesting policy developments in England, particularly in the criminal sector. There are now pilot courts looking at problem solving for parental substance misuse offenders. And also there are special courts that are being piloted again for women. And they're really interesting, linked up to community services, to child protection support in theory, and they are welcomed by the women. But they're very new, far too early to judge whether they're going to succeed or not. So we come to what I think we've used right through these talks today, terms like impediments, obstacles, and here there are clear opportunities and obstacles. The drivers for policy and practice change are certainly in England that there is a lot of interest in problem-solving courts. They're written into the policy, they're actually now being set up, very small scale, but they exist, they're real, small but real. A huge driver, both in the States and here, is the huge, huge costs of parental substance misuse and domestic abuse and offending, and that's a pretty potent driver for change. But the challenges, and this was absolutely joint for us, was that these problem-solving courts, sadly, do not have sustainability. Some of them come and go. They need champions. The infrastructure isn't there to build on, and the funding isn't there. So, you know, they're great in terms of their aspirations, their belief that change is possible, but you have to support it. But it's not followed through. So that's a real problem. And then the problem of silos, particularly relevant for this talk. So the silos are a major issue where each agency works to its own objectives, and those objectives can undermine objectives from collaboration. We don't have the data needed to be able to evaluate how well they're doing. And Caroline particularly wanted this last point about a failure and lack of joined up thinking. So this is really very brief. We're doing a study at the moment trying to map that intersection between the family and the criminal court and to understand the barriers and the opportunities. And so far we've interviewed about 30 judges, quite 15 parents, some for whom things have gone well, others where it hasn't gone so well. They've been very open in sharing. We want to co-write one of the reports with them. And it's a sister project to understand that large-scale data set where we just have the quant information, but we don't know really what lies behind it. Concluding thoughts. Phew. So in England and in the US, we're saying, firstly, perhaps it's not surprising, they are very complex problems. They're complex problems where there's a lack of awareness and a lack or insufficient skills to know how to tackle the problems in tandem, which involve too many agencies. But problem-solving courts, we think, are important because they're based on a holistic approach in real time. And that's what makes them very different from ordinary processors. But they do require the infrastructure, and they need more evidence of how well they're doing. But this is the big message. Whatever happens to problem-solving courts, no matter how much they expand, that ability to look beyond the individual problem to other problems in either the family court, in the criminal court, is vital. And it's how does one do that? So I think I feel very strongly that we have contradictory policies. We say that prisons shouldn't be used. 50% of women at the moment go to prison for short-term offending, stay there for less than 6 months. What does it achieve? And they're still going to build more, though they've put a pause on that. And finally, letting Caroline finish, she said she's been working at this for years, trying to get a co-occurrent perspective, and it's been a huge struggle, and it's a continuing struggle. And as she's put it here, the agencies often actually don't work together, quite the opposite. So Much more needs to be done. It's about awareness, it's about speaking to the policymakers, it's about working with agencies. I was talking at the very beginning with the director here of this particular school who was saying teachers often struggle. Can they raise the issue? What should they do? How do they respond? Question mark, question mark, question mark. And that is where I finish.
Thank you.